Ms. Lhamon, I've got a series of questions, and they really require a yes or no answer. Do you believe in the concept of innocent until proven guilty?
I do.
Do you believe an accused student is entitled to due process in a school disciplinary proceeding?
I don't want to overlawyer my answer. Due process applies in public institutions, and fair process applies in private. And I believe that students should have fair process in administrative proceedings in schools.
How about in public schools? You gave a different...
Yes, I think that the umbrella applies in both places, and I wanted to be precise about the term.
Do you think an accused student should have the right to see all the evidence against them before they're asked to defend themselves against an allegation?
Senator, you asked about a right, and I expect that that means a legal right. And in the current context, the Title IX regulation that is operational now and that I would enforce if returned to the Office for Civil Rights does afford that right to students.
Should an accused student be allowed to see evidence against them that could clear them of charges?
Likewise, Senator, the current Title IX regulation, which is operational now, gives students that right.
Do you think a complainant and an accused student should be entitled to a hearing?
Senator, the current regulation entitles in a higher education institution students to a hearing. There's a different rule applicable for K-12.
Do you believe a complainant and an accused student should have a right to cross-examination?
The current regulation affords, in the hearing process, a right of cross-examination, not student to student, but through a representative.
And of the questions that I asked relative to current Title IX guidelines, of those, how many do you plan to change?
Senator, I won't be in control of what change does or does not happen with respect to the Title IX regulation. There is a process that has begun at the Department of Education, and that process will involve the department and I, if I'm privileged to return, evaluating public comments and listening to the expertise of staff who are at the Office for Civil Rights now, who have, in the 4.5 years since I left, been honing that expertise and applying it to enforcement experience that I don't have because I have not been there.
When you and I met, you told me that you've been painted as someone who only believes victims, but that you didn't agree with that. Would you support keeping a presumption of innocence requirement in the current Title IX rule if the Title IX rule is changed?
And again, with I'm trying not to overlawyer, but there isn't a presumption of innocence in the existing Title IX regulation. And in fact, the Title IX regulation that the Trump administration issued took pains to note that criminal procedure does not apply in schools.
But my question was, would you support keeping a presumption of innocence?
Yes, Senator, I understood that, but I couldn't keep something that is not there. And it is not there now.
Last question. My understanding is that during your time at OCR, you did not conduct any notice and comment rulemaking. Is that right?
That is correct, Senator.
Yet during your time, you issued more than 20 guidance documents. These documents include an expanded definition of sexual harassment, discrimination based on sex, prescriptive grievance procedures, scrutiny over how school disciplines students. None of these documents went through any notice or comment process, meaning people had the opportunity to comment and you could digest that in your final decision. Am I right?
Senator, we did not use a notice and comment process. We did take in quite a bit of information from people with all kinds of views on the various topics, including, for example, on the sexual harassment guidance. There were more than 35 listening sessions at the White House, and there were 3 years of meetings with people of a whole variety of interests on the topic before the department issued that guidance.
Thank the chair.
Senator Casey.
Thank you, Chair Murray.
Circuit court decisions that have been referenced to, 3rd and 6th, respectively, were determined in 2018 and 2020. Were those decisions in place when you were at OCR before? Would that have limited what you would have been able to propose on Title IX, in your estimation?
Senator, had those decisions been in place, the Office for Civil Rights absolutely would have followed them in the jurisdictions that what they are controlling.
Okay, thank you for that. Earlier, you said that the current Title IX regulation didn't include a presumption of innocence standard. And in fact, in section 106.45, the regulation says this, quote, include a presumption that the respondent is not responsible for the alleged conduct until a determination regarding responsibility is made at the conclusion of the grievance process, unquote. So you gave me a crafty answer, so let me ask again. The current regulation requires a presumption that the respondent is not responsible until proven otherwise, which we commonly call presumption of innocence. My question is not about the current regulation, but what you think should be the standard. Should the standard be presumption that the respondent is not responsible until proven otherwise?
Senator, if I may, I did not mean to overlawyer you on that answer, and I appreciate the chance to come back to it. I maybe because I am a lawyer, I am so focused on a criminal process that is different from an administrative process in school. And I will enforce the standard that exists. And to your question about what should or shouldn't be there, I want to say that the views I hold sitting here are not the views that I would be able to impose or not impose. There's a regulatory process that involves lots of people, not only me, that not me at all at the moment, that is underway at the Department of Education. But my view is that civil rights investigators at schools need to start from the presumption that the facts are what they are, and you need to find out what they are. So they shouldn't be assuming somebody is guilty because the person has been accused. Guilt's not even the right word, so now I've walked into the criminal process. They shouldn't be assuming that someone is responsible because a person has been accused. They should be open to the possibility that the person is not. And I absolutely support that, and I think that's important in an investigative process.
I'm appreciative. That clears some things up. It doesn't go unnoticed that you have repeatedly answered on this side of the aisle that you're really not in control, that there's a process. But when you answered over there, your answer was you accept that you will have authority and responsibility for policy and recommendations made by your office. Can't be both ways. And it's not a question.
Okay.
I just want to point it out because I think sometimes it's good to reflect on what you've said and to whom you've said it. I think that we have tried to emphasize the fact that public comment, transparency, input, comments are an important part. And that was not necessarily the pathway you chose last time you were in the office. I hope this time we will choose a pathway that does include public comment. If that's what the office is doing currently before you are confirmed, great. I look forward to you sharing those comments with us prior to any decision that you might make. I thank the chair.
Ms. Lhamon, do you want to respond?
Thank you, Senator Murray. And Senator Burr, first, I appreciate your confidence that I will be confirmed. So thank you for that. And I did not mean to communicate a different answer to one side of the aisle than to the other. I said in my opening that I believe civil rights are bipartisan. I believe that they are. And I would be even-handed in the ways that I work with members of Congress, and I would be even-handed in the ways that I would be enforcing the law if I were confirmed to the office.
Thank you. That will end our hearing for today, and I want to thank all of our colleagues for their participation. I really want to thank all of our witnesses, Ms. Lhamon, Ms. Brown, Mr. Rodriguez, for your time and for your very thoughtful answers to all of you. I look forward to working with each of you to tackle the challenges that students and educators and schools are facing. For